Okay, so my name is Kevin Collins. I am a professor at the Washington University School of Law, and I am here today to talk about a new way of trying to think about a consequentialist justification for Section 101. Basically, the talk's going to string together three concepts that I'll present and try to round out for you. The first one is that there is a particular kind of technology, a grouping of technologies that I think is at the core of a number, not all, but a number of the patent eligibility disputes that are going on today. These are technologies that I'll refer to as non-spatial technologies. Diagnostic Inferences in Computer Software are two examples of these that I use. I'm going to argue that non-spatial technologies have a particular effect within the patent system. They cause what I'll say is regulatory inefficacy. That is, certain of the patentability conditions are only effective at reining in what constitutes a patentable invention when they are brought to bear on spatial technologies. So therefore, when we have non-spatial technologies, we end up with ineffective regulation and unusually permissive standards for granting a patent. Given that as a premise, we can then say when there's regulatory inefficiency, this can actually support a different role for patent eligibility. Patent eligibility can actually be thought of as a counteracting force. A restriction on patentability can actually counteract the technology-specific regulatory inefficiency in the patentability conditions, bringing strictness of validity regulation back to closer to par for all technologies. So I'm going to walk through these, but in the presentation in the opposite order, kind of get into each of them. I want to just put up in the front, however, that I'm not trying to argue that I'm justifying the Mayo and Alice cases as they exist. As they were written by the Supreme Court, that's not at all true. What I'm doing is offering a way of justifying some restrictions on patent eligibility, and there's going to be an imperfect fit between the restrictions that I can justify and those that are in the Supreme Court opinions. So as I said, I'm going to do this presentation kind of backwards. Okay, so first, conventionally, when we think about how we justify restriction on patent eligibility, I think this is the normal viewpoint, right? We say that, look, the patentability conditions impose a restriction on what constitutes a valid patent interest. So the higher the bar here, the stricter the regulation and the fewer the patents that issue. And we would say, oh, when you've got patent eligibility restrictions in a field, you end up with stricter validity regulation in that field as a whole. And we look for justifications about why we might think that stricter regulation is appropriate. Maybe there's high gross costs from patents. Basic tool explanation. Maybe there's a low gross benefit. See Strandberg, who's going to be talking later today. However, there's an assumption in this conventional justification, which is the patentability conditions really can do the same job in all different technologies. What if we take a different assumption? What if we actually say in particular kinds of technologies, the strictness of the validity regulation for one reason or another is not as strong? If you believe this, then you can say maybe we can use patent eligibility not as something that increases the strictness of validity regulation for a particular technology so that this overall strictness is greater than in some other technology. Rather, we're doing something that's closer to bringing the overall validity regulation back to closer to par. So this is in this counteraction theory, we're changing the goal of Section 101. We're no longer saying there has to be stricter regulation in a particular technology. Rather, we're trying to get comparably strict scrutiny in all different technologies. And we therefore change the key question in normative justification. Usually we scratch our heads and say, why does a particular technology merit stricter scrutiny or less patent protection? Here instead, I'm going to be asking a question, when do the patentability conditions give rise to heretofore hidden reduced scrutiny on the validity of particular technology? Okay, so why do the patentability conditions give heretofore hidden reduced scrutiny on the validity of patents in particular technologies? Well, this is where the next concept comes in, where I'm going to talk about regulatory inefficacy. I will argue that some patentability conditions are ineffective when they're brought to bear on claims to non-spatial technologies. They're simply unable to do the welfare-enhancing job of regulating patent validity that we expect them to be able to do. A simple metaphor here might be helpful. Patentability conditions are tools. We're accustomed to this in the policy lever metaphor. I'm actually going to think about them as policy wrenches, kind of lever for metaphorical convenience. The key insight here is that wrenches and most tools only work when the claimed properties have certain kinds of, claimed technologies have certain kinds of properties, right? When we bring a crescent wrench to bear on something, we want it to have the shape of a nut to latch onto. Similarly, I'm going to be arguing that certain patentability conditions, sections 102, 312 of the Patent Act, can only do their cost-effective work when the claimed technologies have certain fundamental properties. When, in the wrench example, a particular technology lacks the property upon which a tool depends in order to be able to do its work. If you try to bring a crescent wrench to bear on a screw, the wrench is going to be ineffective. In the same way, when you try to bring a patentability condition to bear on certain technologies that lack the properties of a spatial technology, those patentability conditions are going to be ineffective as well. One thought is that we can use a sui generis tool, perhaps patent eligibility, to step in and do the cost-reducing work that the patentability conditions are not doing. So what's new here? One thing that's new is I'm flipping around the arguments that are commonly made about the relative merits of the patentability conditions and the doctrine of patent ineligibility. I would call the conventional argument against restrictions on patent eligibility the Annie-Oakley theory of patent eligibility, which is Annie-Oakley theory of the patentability conditions. Anything patent eligibility can do, the patentability conditions can do better. Whereas I'm going to flip that around and say, look, actually sometimes we need restrictions on patent eligibility precisely because the patentability conditions end up being ineffective when they're brought to bear on a particular type of technology. And also it's a new kind of technology specificity. Generally, when we're talking about technology specificity in patent law, we're talking about the economic profile of innovation. Are there some costs or unusual dynamic costs that come out of patent protection? Whereas I'm talking about a kind of technology specificity which is dependent on the ontological nature of the technology. There's certain intrinsic fundamental properties of a technology that screw up the way in which the patentability conditions, or some of them anyway, usually work. Okay, so I've gone through two of these chained concepts. I've talked about patent eligibility as counteraction, and then regulatory inefficacy as a reason why we might want to have, be using patent eligibility as counteraction. Final question we need to get to is, so what are these fundamental properties you're talking about, Collins, that have to exist in the claimed technology for the patentability conditions to be effective? This is where a third concept comes in. I'm going to distinguish something that I would call a spatial technology from a non-spatial technology. Now this is a very fundamental set of properties that most all technologies that are patented possess. So it's only going to be a very small fraction of technologies that I would end up calling non-spatial. Spatial technologies are simply technologies that exist when they are infringing embodiments in the three-dimensional world of spatial extension. And furthermore, their spatial extension, that is, their spatial configuration, the arrangement of the technology in space, has to in some way be relevant to the definition of what an inventor has actually invented. I'll come back and look at this a little more in detail by talking about some examples of non-spatial technologies. But first I want to emphasize these properties of a spatial technology are very fundamental. It's not, even though I use the wrench and the nut class analogy, I'm not trying to say change a technology from being hexagonal to round and all of a sudden the patentability conditions don't work. Most patented technologies are spatial technologies. In fact, all technologies, I would argue, that were within the reach of the patent regime when the modern patentability conditions evolved are spatial technologies. So this, in a sense, tells us why there might be this technological specificity, because these were the only technologies around and the only technologies that likely could be imagined by judges who were trying to figure out how they could create tools to regulate patent claims, if the only things that you can think of that need regulating are spatial technologies, it's very likely you're going to come up with tools that are only effective on spatial technologies and might not be as effective for completely other types of technologies. Today, however, I'd argue some technologies are no longer spatial technologies. For example, and these are the two that I worked through in the paper, diagnostic inferences. When we start to claim a diagnostic inference, there's, as in Mayo, there's actually one limitation of the claim which does not describe a set of things in the world that belong to a category. Rather, they describe the use of concepts that mark those categories within thinkers' minds. And I will argue that diagnostic inferences are non-spatial technologies, and therefore a number of the patentability conditions that we usually rely on to reduce the costs of patent claims fail when they're brought to bear on diagnostic inferences. Computer software, a non-spatial technology for a slightly different reason. Here, it's certainly a spatial technology in the sense that it exists in the world of three dimension. Computer programs, like program computers, I can kick them. However, the arrangement of the technology in space, that is to say its spatial configuration, isn't relevant to the definition of what an inventor has invented. This is inherent in the functional nature of software. So here's the paper, which it's generous for me to call it a paper because it's about 3/4 of a paper, or in its most recent iteration, it's only 3/4 of a paper. This has undergone a lot of change over time. However, the bulk of the paper, I have an initial section on introducing the theory aspect. The bulk of the paper is actually oriented towards proofs of concept. I look at diagnostic inferences in computer software. I try to identify particular patentability conditions where I say these patentability conditions fail because of the non-spatial nature of the technology on which the doctrine is being brought to bear. So it's overbreadth and inherency when we're talking about diagnostic inferences, and it's the means plus function rules or written description when it is computer software. The final thing I do in the paper is to try to look at the fit between the restriction on patent eligibility that I can justify based on regulatory inefficacy and the Mayo and Alice cases that were decided by the Supreme Court. And it's a mixed bag. I can justify some aspects of them, but not all. This is not an apology to try to defend the Supreme Court opinions as they were written. Okay, so due to limited time here today, I'm going to put the computer software stuff aside because I've just spent 12 minutes talking about the theory part, which I deal with in a more abbreviated form, or is a smaller component of the paper. I'm going to talk about this diagnostic inferences section and try to give you a hint about why I think there is regulatory inefficacy that goes on here, and a little bit about the fit between the justification of restriction on patent eligibility based on a counteraction theory and Mayo. Okay, so first thing I have to do is say actually diagnostic inferences are non-spatial, that they're literally conceptual technologies. The spatial technologies describe sets of things or processes that exist in the world of extension, right? Fruit, or the process of eating fruit. However, the diagnostic inferences, one limitation thereof always describes a mental inference in the mind of a doctor that directly manipulates concepts. So here, when we're thinking about fruit, the way in which fruit actually exists in someone's mind is radically different from the way in which fruit exists out in the world. Here it is a concept itself. Here we have things in the world that we use words that invoke concepts to refer to, but we have things rather than the concepts themselves. And we can see this in the Mayo claim itself. It's that third step, which is clearly a mental inference, which is based on a particular set of concepts that exist in a doctor's mind. When we have literally conceptual technologies, I'd argue that there are two bedrock patentability conditions that simply fail to operate like we expect them to fail, like we expect them to operate when in the normal course of things. So first, overbreadth. Overbreadth, I think we all know what this is. It's a way of me talking about both enablement and written description. It invalidates claims when the set of technology is too large with respect to the disclosed set. So we have a specification that discloses a smaller set of technologies, then we allow the claim to expand beyond that and encompass a larger set. And we know that overbreadth caps permissible patent generality. Overbreadth only works because claim generality is a set theoretical construct. That is, the larger the claim scope, the larger the set of distinct objects within the claim. In fact, that's the definition of claim generality most of the time. And furthermore, inventor disclose things that are closer to specific things or smaller sets of things, and then we allow claim scope in some way to generalize beyond that. A larger set of things ends up being claimed. But what's important is the set of things within claim scope expands as claim scope expands. In fact, it's impossible to have a thing which is the generality, right? A generality only exists as a collection of specific things. This is very different when we start to get into concepts. Concepts can be intrinsically general. It is entirely possible to invent diagnostic inferences based on highly general concepts without ever possessing anything more specific within them. That's an impossibility when we're talking about claims to spatial technologies. So when a researcher discovers a highly general factual truth, she actually enables and possesses inferences that employ that factual truth even though she has no knowledge of more specific correlations. Simple example, right? Fever and illness. Imagine a patent claim back from the day when a doctor realizes that fever is correlated to illness, and you can use measuring a fever as a way of diagnosing some kind of general illness. At this point in time, the doctor possesses a highly general diagnostic inference because they have two general concepts, fever and illness, that they have demonstrated exist in a correlated fashion. They possess nothing more particular. You disclose the correlation between fever and illness, and you have fully enabled and possessed the general claim without having any knowledge of anything more specific within it. Claim generality in concept land can be intrinsic. Concepts grow intrinsically more general rather than the claims coming to encompass larger sets of distinct things. And when that's true, when generality works in this manner, traditional overbreadth fails to effectively regulate permissible patent generality as we are accustomed to it doing, precisely because claims can have intrinsic generality. Inherency works in a similar way. We would depend on a distinction between new things and new knowledge. However, that distinction breaks down when we start to talk about concepts because a new diagnostic inference employs new concepts, and whenever you've discovered new knowledge, you've created a new concept, and therefore you have a novel claim within the mind. You discover new properties of a known diagnostic inference, and you have a novel diagnostic inference. You don't have to, there is no distinction between the things that are being claimed and the novelty of the concepts, which, under the usual inherency rules, don't lead to novel claims. So, to recap, I'm saying that there's certain kinds of non-spatial technologies. Some of the patentability conditions fail to work, so we have regulatory inefficacy, and this might be able to justify a restriction on patent eligibility because Section 101 hopefully will step in and do some of the needed work. Finally, the fit with Mayo. I'm not trying to say that this theory can justify any restriction on patent eligibility at all. That clearly is false. It's only a set of very limited restrictions where what you're doing is compensating for regulatory inefficacy within the patentability conditions. So in the Mayo case, I would argue that there's a poor fit between Mayo and my theory insofar as I'm viewing Mayo as a mental steps case, whereas Mayo views itself as a restriction on patentability patent eligibility that keeps patent law out of the natural. However, one aspect that does fit very well is the point of novelty or inventive concept approach, because as I suggest in the paper, the regulatory inefficacy of a claim that recites a literally conceptual technology only exists when that literally conceptual technology is the point of novelty of the claim. I don't have time to work through that here, but that is the argument. So that's a big overview, very quick, of a way I'm trying to rethink, or another way, an alternative. I'm not trying to displace the conventional justification of patent eligibility, but say, oh look, here's another situation in which perhaps some types of restrictions on patent eligibility can have a consequentialist justification. Okay, Becky.
So I'm not sure I understand this, so this may be a bad first question, but so if you The way it seems like these restrictions on patent eligibility are working now is that they're not excluding fields
Yes.
from patent protection entirely. They're excluding certain kinds of claims.
Mhm.
So is your argument really that the exclusion of some of those claims but not others, that is equivalent in terms of delineating, drawing a line between what's patentable and what's not patentable to the work that might otherwise be done by these other doctrines that you see as not working? Or is it that these doctrines don't work and therefore we're going to keep these fields outside of the patent system? Do you see what I'm saying?
So I would say it is the former of those two.
Yeah.
Because if in fact this were if I viewed a restriction on patent eligibility as just getting them all the way gone, right, then this arrow would be infinitely high, right, on this chart. I'm actually viewing them as not as categorical exclusions of particular types of technology, but of particular, well, it depends upon how you define a type of technology, but a particular field of industry, right, is not excluded by my vision of what patent eligibility does.
Or borrowing from Strandberg's paper, you're not trying to create a patent-free zone.
Mm-hmm.
You're trying to create a zone in which patents are more parsimoniously awarded than they would be if we had to rely on the tools that we've developed for dealing with the spatial inventions.
And I would argue that both Alice and Prometheus can be interpreted in that way. Whether Prometheus is actually going to be interpreted that way is another question, whether all diagnostics are off limits, right?
1 minute.
Okay. Mark?
What do you do with Myriad and Funk Brothers and Products of Nature? Are they just outside this universe? Because that sure seems to me to be spatial technology.
Yes, no, they are outside this universe, and in fact, I would argue, I have a final slide saying what I'm not doing here. I'm at a loss to understand how I could use this theory to justify any restriction on patent eligibility that is based on keeping patents out of the natural. That's just something that I'm not doing.
So, Kevin, I wonder how generalizable your argument is. So, in the software field, which I know we didn't have time to talk about, people just say, we can't find regular prior art. Forget inherency, right? The regulation doesn't work because there's no good prior art in software. Is that sort of a species argument? Does it apply to spatial only? Because that's beyond spatial type argument.
So, there could be, I am making an argument that is initially narrower, right? Trying to say, look, these are particular, for lack of a better word, ontological characteristics of this technology that mean the traditional wrenches just don't work here, right? Whereas you're taking it one step further and saying, well, it's entirely possible for non-obviousness and novelty to work in an effective manner in these areas, but for practical reasons, it turns out that the doctrine is ineffective, therefore maybe we need to call on patent eligibility in order to do it. So I am trying at first to make a narrower argument out of this, but it certainly could be stretched in that manner. I'm not yet sure whether I endorse it being stretched that way. I think I'm out of time, unfortunately. Thank you.